So welcome everybody to the first seminar of the Health Law and Ethics Network series for 2022. I'm Paula O'Brien. I'm an Associate Professor at Melbourne Law School and I'm one of the directors of the Health Law and Ethics Network. I acknowledge the Wurundjeri people of the Kulin Nation as the owners of the land on which the Melbourne Law School stands. It's the unceded land of the Wurundjeri people. I pay my respects to their elders, past, present and emerging, and a very warm welcome to any other Indigenous people who are joining us today. So this year, HLEN is again presenting its seminar series on the research that's coming out in the health law and ethics space. And we at HLEN see this seminar series as a great opportunity for the sharing of research that's being conducted around health law and ethics amongst other researchers at the University of Melbourne, at other universities, and in the wider community. So we're always very pleased to welcome a really mixed audience of academics, of doctors and clinicians, of legal practitioners, of regulators, policymakers, a broad range of people who come to these seminars. And these seminars have been really a great launching point for some really excellent research collaborations across the University of Melbourne. So we're hopeful that this year's series will again be so fruitful and so productive. So we're very pleased to start the seminar series this year with presentations by colleagues from the Helix research group at Melbourne Law School. We have Dr Megan Prictor, who's a senior lecturer at Melbourne Law School, and she's going to start today's seminar with her presentation on recording our genes, identifying optimal legal settings for clinical genetic data in networked medical records. And then she's going to be followed by Professor Mark Taylor, who's the Deputy Director of Helix at Melbourne. And he's going to be presenting on protection of genomic data and the Australian Privacy Act. When is genomic data personal information? And in the discussion time, which will follow both of the presentations, Mark will also be joined by Minna Paltiel, who's a lawyer and a PhD candidate at Melbourne Law School, and by another, possibly one of his other co-authors to answer questions and to take part in the discussion. So we really thank Megan and Mark for these presentations, and I'll hand over to Megan to start. Megan will do her presentation, Mark will do his presentation, and then we'll have about 15 to 20 minutes for discussion. So thanks, Megan.
Thank you, Paula, very much. And thanks everyone for joining. I hope you can see the slides okay. Great. So I also acknowledge that I'm joining you from the beautiful lands of the Wurundjeri people of the Kulin Nations and pay my respects to their elders. Today, I'm going to be presenting on a small project, a pilot project funded by the University of Melbourne as part of an early career researcher grant for 2021. And the project's called Recording Our Genes, Identifying Optimal Legal Settings for Clinical Genetic Data in Networked Medical Records. Quite a mouthful. So what am I talking about today? Well, so in Australia, we've seen rapid growth both in clinical genetic testing, more than 1.2 million clinical genetic tests over a one-year period in 2016-17, and that figure is expected to grow exponentially, and it's similar case internationally, as well as a rapid growth in networked electronic medical records. And what do I mean by this? So I mean medical record systems that are accessible via computer to different healthcare practitioners in different locations. So the My Health Record system is one example of that at the national level, and it's reflected on a slightly smaller scale by statewide systems in some locations, and also large systems across networks of hospitals or general practices. So in Melbourne, we have the Parkville precinct with 4 major public hospitals all connecting via a single Epic system. Not a single Epic system, but a connected Epic system. I want to make the point, because it connects to Mark's talk that's following this, that when I talk about clinical genetic test results, I'm talking about identifiable personal information under the law. So my interest is very much in the types of test results, whether that's a single gene test or panel test, the type of information that ends up in a medical record, as distinct from a genomic whole sequence database that might have a whole a wider variety of information that's not necessarily clearly pertaining to a particular person's health result, if that makes sense. So joining up the dots between these two things, the growth in genetic test results and the proliferation of networked EMRs, is in fact a national policy priority. It's designed to, getting the test results into these types of systems is designed to improve the integration of genetics with other types of healthcare provision, the safe retention of this important information over a very extended period, and a reduced need for retesting when results aren't available at the point of care when they need to be. But this would be a significant shift in practice. Genetic test results are typically highly protected and are often kept in separate systems precisely to tightly limit access to them. And so we wanted to examine whether in this brave new world where our genetic data is more readily available in networked type medical record systems, is the current regulatory framework for that sufficient to promote privacy, trust, and appropriate sharing of those results. So the aim of the project was to identify legal and governance barriers to the trustworthy use of networked electronic medical records for clinical genomic information and to develop recommendations for reform. We wanted to know more about stakeholder views on the upload of genetic test results to EMRs and the use of these systems to store and disclose this information, as well as about how the law and governance might currently accommodate users' preferences and the design elements of networked systems, or whether they might need amending in order to do so. We interviewed, so this was a two-part study. We conducted interviews with important stakeholders, and then we looked at what the law said about some of the interview findings. So we spoke to health professionals that included genetic counsellors, clinical geneticists, and specialists dealing in conditions that had a genetic element or basis. We also spoke to people who've had a genetic test. I'll refer to them as patients for shorthand purposes, the parents of children who'd had a test, and also representatives of advocacy groups for people with health conditions that have a genetic basis. All of our interviewees were located in Australia. This was a fairly small study, as I said, so we had 27 participants. We spoke to them over Zoom for up to an hour in the middle of last year, and we asked them about their thoughts on how genetic test results are currently stored and shared and how they ought to be in the future, what risks they foresaw, what benefits they foresaw, and so on. We analysed the data in vivo using an inductive thematic approach. And that piece of work is to be published this year in the Health Information Management Journal. And then we turn to map relevant legislation, both at the Commonwealth and the state and territory levels. And this is particularly the Privacy Act, the health records laws, or the information privacy laws as applicable. So I won't present you with all of the findings of the research, that would take far too long, but I'll highlight a number of the themes that emerged. So we identified 5 key themes from the interview data, and I'm going to speak in particular today about 3 of those. Firstly, varying preferences for the degree to which medical record systems should enable access and sharing of genetic test results, how to accommodate family interests in genetic information using these systems, and also external risks in terms of security and access to results. And the one that I'm going to speak about today is access by enforcement agencies, specifically the police, but there were other themes that emerged as well. So in terms of the first one, our findings were across a very wide spectrum in terms of people's preferences for how openly available or how tightly constrained genetic test results ought to be in terms of their storage and accessibility on medical record systems. So right at the highly available end of the spectrum, people said things like, well, this is important medical information, why wouldn't you share it? They didn't distinguish genetic results necessarily from any other type of health information that needed to be available at the point of care when it was needed to inform care. Parents of children who had had testing in particular saw the increased availability of these results via network systems to be a great bonus in terms of reducing their burden, doing away with the need for them to constantly redisclose information. And one parent in particular said, if it was available to the clinician when I saw a new clinician, then I wouldn't have to have that difficult conversation in front of my child if the clinician already had that information on the system. To be fair, a substantial number of our participants also said they hadn't given much thought to where their test results were stored and who had access to them, and they didn't particularly care. It wasn't high on their list of priorities. But moving towards the other end of the spectrum, there were also strong views that the patient should have ownership of the data and be able to exercise control over that. And associated with that, a view that it should be disclosed very selectively, that whether that was at the control of the patient or of the health professional, that it should be only available in a very limited way. So how does the law, I suppose, respond to this, or how might it enable this flexibility, this range of views about appropriate access and sharing? Well, of course, the law focuses on privacy protection with exceptions. And so these exceptions include the consent of the patient. There's a provision allowing for disclosure without consent on the basis that the patient would reasonably expect it when it occurs for a directly related purpose, or in rare circumstances, disclosure to a genetic relative without the patient's consent. So this approach is not necessarily a great fit with networked EMRs, generally speaking, where the information is potentially available to anyone working in a whole health system or a whole group of hospitals, which is partly probably why genetic test results have often been kept in separate systems outside of the main hospital record system. Nor do networked EMRs typically accommodate patient preference or control over their information, although this may be coming. We're seeing signs of this. The Royal Children's Hospital patient portal has some limited capacity for parents of child patients to be able to push information out from that system to other health professionals. And so the law, I'd say, generally enables the protection of information with exceptions rather than enabling that kind of other end of the spectrum of making information highly available. The second theme was accommodating family interests, and there were really interestingly diverse views about whether genetic results are properly the domain of the individual or the family that emerged both from our clinician interviewees and our consumer interviewees. Clinicians said that they were challenged by the need to maintain family-based genetic information and results in record systems that were really premised on the individual patient. And so this again drove the establishment of whole separate systems that were set up to record kinship information and to collect results that was separate from the main medical record. Consumers were also aware of the complexities of this issue, particularly in terms of disclosing and index patients' results that might have implications to other family members, to other members of the family. They reflected that everyone's family is different, communication styles are different, and it might depend on the type of condition that was at issue as well. I do think it's a bit hard to see how a networked EMR would actually help resolve these complexities, because the paradigm is still really around the individual patient record, and the networking, the net element is mostly on the clinician side, not the patient and family side. There are strong policy and practice I suppose commonalities that would need to be changed. So the emphasis is really on disclosure either by the patient themselves to other family members or with the patient's consent by the health service to other family members, but that happens not within the EMR itself. just jumping down, there was some support in the interviews for a networked EMR as a safe and lasting repository of information that could enable family communication over time. And as I mentioned earlier, a system that allowed patients to push their personal information from the system to other people would be of benefit, I think, here, using the legislative exemption from privacy principles for personal, family and household affairs. A third theme that I wanted to cover is that of external disclosure. I'm particularly interested in disclosure to law enforcement. Now, this might seem a bit of a tangent perhaps, and also might seem a bit fanciful, but you know, Bartha Knoppers and others have written about a likely future scenario where all babies have their whole genome sequenced at birth, and that data is stored for repeated interrogation across the lifespan. And so potentially networked EMRs could play a role in that kind of future. And so actually, I don't think it's as far-fetched as it might initially seem. In all jurisdictions in Australia, the Crimes Acts have provisions for DNA collection, so sample collection for forensic purposes, but they don't touch upon secondary use of existing genetic information from genetic tests or from health-related systems. And so it's possible, theoretically at least, that access via health records could be used to avoid all of the loopholes that have to be jumped through under the criminal law. I'll give you the specific statutory provision in a moment, but our interviewees were really quite surprised most times to learn that enforcement agencies in Australia can legally be given access to health records without the oversight of a court. And they assumed that a warrant would be required and that the individual would always be informed. This was a very strong view. So the Commonwealth Privacy Act and relevant state and territory laws do allow disclosure by data custodians to enforcement agencies without the individual's knowledge or consent. This usually requires the data custodian, so the hospital or the clinician, to have a reasonable belief that it is reasonably necessary to disclose the information for the purposes of enforcing the law, or there are other provisions about protecting government interests or public revenue. There is precedent for such disclosure, although it didn't relate specifically to genetic information. So 2 cases before the Privacy Commissioner on the disclosure of people's health information from their health records to law enforcement without their knowledge or consent under this reasonable belief in reasonable necessity provision. I have been reassured by health information managers at hospitals and so on that this would in fact not happen, and that the knowledge of the gatekeepers, the internal policies, the ethical norms, the guidelines of the colleges and so on would be enough to mean that in practice, the gatekeepers would always insist on a court order or a warrant or the consent of the patient. But given that the provision exists and given that it has been used for other types of health information, I'm not convinced that this is enough. Which leads me neatly to my final point about the My Health Record system. And I think its design and statutory settings could provide a useful model here that we could draw upon in thinking about how the law and networked EMR systems could be used to capture and utilise and better protect and enable patient control over genetic test results. So this might seem a bit strange because My Health Record system has had so much bad press, but bear with me. So the system itself was built as a networked system. It's accessible to us as consumers or patients and to any clinician who is providing us with care. It has its own bespoke legislation, the My Health Records Act 2012, and statutory rules. So how might that system and the law that underpins it accommodate some of those themes that have emerged from our research? Well, first of all, information in the system is by default available to any treating clinician. So it ticks the box in terms of that highly available end of the spectrum. But consumers can also access control over either their entire My Health record or individual parts within that record, individual documents. So they can set a PIN that the doctor would need to ask for before the doctor had access to that that document or to the record as a whole. You can also set notification preferences, so you can be alerted when someone has access to your record, and there is an audit trail that is visible to the patient, to the consumer, so you can see who's gone in and had a look at it. So it does actually seem, I think, to accommodate quite well the variety of preferences for information control versus accessibility that we were reflecting on earlier. In terms of accommodating family interests, I still have some questions here. I don't think this perfectly resolves it at all. It is still premised on the individual patient, not a group or a whole family, but it does at least provide a safe and lasting repository of information that is under the control of the consumer. And that if there were added to the system something like a push option where patients could push out information to other people that they wanted to be able to see their test results, for instance, that could be a useful addition. The other interesting element, I think, of My Health Record is that in terms of external agency access. So originally, the My Health Records Act was modelled on the Privacy Act, and it included that provision about disclosure without consent from the system if the data custodian, here the Digital Health Agency, had a reasonable belief in the reasonable necessity of blah, blah, blah for enforcement purposes. However, in the context of the very substantial public backlash against the rollout of the My Health Record across the country in 2018, the legislation was amended, and that particular provision was removed, and the hoops, there were extra hoops put in that enforcement agencies wanting information had to jump through. So they now have to seek a judicial order, and there must be no other way for them to obtain the information that they're seeking from the My Health Record. So actually, Mark Taylor and myself and others have written on this for the conversation if you're interested, but it does seem that tightening of that particular provision could be a useful step. So in summary, our research has yielded an improved understanding of the needs, preferences and concerns of stakeholders, albeit in a small sample, with regard to genetic test results in networked electronic medical records. The current statutory settings don't seem to be a great fit with some elements of the system design, particularly with regard to genetic test results, and this could impede progress towards those national policy goals that I highlighted on the first slide. It's unclear what the impact of the Privacy Act review reform process currently underway might be in this arena. And as I said, the My Health Record could offer a surprisingly useful model, both in terms of its design and its underpinning legislation. Finally, I just want to thank particularly my research assistant, Maria Richkova, and colleagues on the advisory team for this project who are here today, including Mark and Professor Jane Kay. Thank you.
That was fantastic. Thank you very much. So why don't we move straight into Mark's presentation, and then we'll have time for some discussion on both the papers. Thanks, Mark.
Thanks, Paula. It's great to be here. It's great to see you all. I look forward to hopefully later in the year having some of these in person and seeing you in person. But thank you for joining us this afternoon. Although we're all in different places, I too am joining you from the land of the Wurundjeri people and would like to join colleagues in paying my respect to elders past, present and emerging. So what I am presenting on is a work in progress. It's a paper that's being written with co-authors, Professor Ainsley Newson and Minna Paltiel, doctoral candidate here at Melbourne Law School. And the three of us are working on this paper as part of a broader Australian Genomics funded project, which is led by Ainsley. And I'm delighted that Ainsley and Minna are both here with us this afternoon, so they can both correct and complement whatever it is I have to say with their own thoughts. It is, as I say, a work in progress. It is a paper that's being written. So if you are interested in the content, then please do reach out, because it would be great to have some people willing to comment on drafts and to just help us push this work on. Now, Megan was talking there about controls which exist in relation to genetic test results and understanding the extent to which those controls fit with people's expectations and preferences. Now, that was premised upon an understanding that the genetic test result is in fact personal information or health information, and understanding the extent to which either the Privacy Act or indeed the My Health Record Act, which uses the same definitions as the Privacy Act, engages and subjects that data to control. Now, there is a prior kind of question, which is, well, when is this information subject to the control of the Privacy Act and the My Health Record Act? And this was a question that Ainsley recognised to be a question that professionals were asking and weren't necessarily finding easy to answer. And the project is intended in part to help provide guidance on that point. But it was a question that not only was identified within the context of the project that Ainsley is leading, but also I thought I'd mention the fact that the same issue came up in a separate piece of work that I was involved in with colleagues at the University of Tasmania and Helix here at Melbourne Law School. This is a report which is coming out very soon on the University of Tasmania's website as a working paper, but it was a piece of work that was commissioned by the Department of Health. And it was to look at different issues of concern to various stakeholders in relation to the regulation of genomic data in both clinical and research contexts. And I won't go into a lot of detail in relation to this report, but just to note that one of the questions that came up when we did consult with stakeholders that was a question of concern related to this: when is genomic information, personal information, under privacy law? And within this report, we note that genomic information will typically only fall within scope of privacy law if it meets the legislative definition of personal information. And it can be difficult for those who are processing genomic information to confidently assess when it's reasonably identifiable. And this is particularly the case when data is moving between different contexts. This question about assessing reasonable identifiability, I think, is challenging because people sometimes aren't sure whether they're trying to assess whether or not something is identifiable in principle. Is it scientifically possible to identify an individual from this data? Or is there actually a legal test which is distinct from that of scientific possibility? And of course, when we're talking about reasonable identifiability in law, it is a legal standard and threshold that we are going to be talking about. And that's partly what we want to try and unpack within this paper, the relationship between the different concepts. So let me try and explain what I mean by that as simply as possible. So we recognize that the law deals with this concept of genetic information. There is a statutory definition. It is a term which is used within the Privacy Act, for example. The term genetic information is in the Act. But genetic information within the Act is part of a broader concept of personal information, which is defined within the Act. That's a legal concept. It's given a legal definition. Its boundaries are established by the rules and the methods of legal argument. That's distinct from the concept of genomic data as we may understand it within a health, research, scientific context. The epistemic basis of these concepts is different. So it's quite easy to just assume that when we're talking about genomic data or genetic information, we're going to be talking about the same thing. And that the boundaries of the scientific or the concept as used within the context of health and medical research, the boundaries are going to be coterminous with the boundaries of genetic information in law. What we are suggesting is that that's a mistake, just to make that assumption, and that actually we need to understand how genomic data is understood within health and research context, and understand how genetic information is defined within a legal context, so we can see where they overlap, and to the extent it is a perfect overlap, and to the extent it's not, what data is going to be regulated as genetic information by law. So let's start by saying how we're using the term genomic data within the paper. We're using the term genomic data. So genomic data distinct from genetic information. Genetic information is the term which is used within the Act. So we thought it would be useful to use the term genomic data to signal we're talking about a different concept here. When we use the term genomic data, we're talking about the concept as it would be used within the context of health, medical research. We're talking about raw sequence data, whole genome, exome sequence, single nucleotide variants, single nucleotide polymorphisms. So we're talking about the raw CTG, the sequences, ACTG, etc. And we're also talking about the analyzed data. So when those sequences are interpreted and understood to signify particular variants. So we might then begin to label particular sequences, sequence data, as having significance as a variant, or perhaps a variant of unknown significance. But we might start writing down this genomic data in a variant call format. So it might end up as a VCF file which has particular variant identifiers within it. And this data may also be annotated with an understanding of significance of that variant clinically, or it might be complemented and supplemented with other biographical or clinical data. Within the paper, we describe that kind of data as supporting data, and we distinguish it from genomic data, as we're using the term within the paper, which is restricted to raw and analyzed data. So within the paper, we're not addressing things like family history, for example. But this is how we're using the term genomic data. And what we're then doing is we're saying, well, how does that fit with the concept of genetic information as described in law? And the first thing to note is that genetic information is a subset of personal information. So as far as the law is concerned, it can only be genetic information for the purpose of the Privacy Act or the My Health Record Act, if it is first personal information. So the preliminary question is always, well, is this personal information? And the Privacy Act says that personal information means information or opinion about a person, information or opinion about an identified individual. I was looking for a clock as I said that. I just realized I didn't know when I started talking. Right, so the Privacy Act says personal information means information or an opinion about an identified individual or an individual who is reasonably identifiable. It goes on whether information or opinion is true or not, whether information or opinion is recorded in a material form or not, but we're going to focus on those bolded text. Information or opinion about an identified individual or an individual who is reasonably identifiable. This clearly has two prongs. The first prong relates to the word about. Is this information about an identified individual? And the second prong relates to whether or not that individual is identified or is reasonably identifiable. Actually, within this paper, we don't go into the question of about. It is a really important question, but we pick that up in a separate paper because these things are so, well, they warrant rigorous consideration in isolation. So this question about whether or not an individual is, whether information is about an individual is not a question which I'm going to further pursue in this presentation. It is one we're interested in, and it is one which is relevant to the Privacy Act review, which is ongoing, where the suggestion is we might move from a definition of personal information that focuses on whether information is about an individual to whether it relates to an individual. And we have, that may have implications for the scope of the concept of personal information. And it's also an important one in relation to the questions that Megan was raising about the familial nature of genomic data, whether or not data is about a person. In that, I'll just say that the courts have indicated that in order to be about a person, an individual needs to be a subject matter of the data, but it need not necessarily be the only subject matter. So anyway, this paper is about how you determine whether the individual that the data is about is identified or is reasonably identifiable. They have to be identified or reasonably identifiable for it to be personal information. If it's personal information, then the question then arises, is it genetic information for the purposes of the Act? And the Act has within it a category of information which is subject to special protections, and that's sensitive information. And there are a series of categories of information which are recognised to be sensitive. This includes health information, and health information itself is further broken down into different subcategories. And one subcategory of health information is genetic information about an individual in a form that is or could be predictive of the health of the individual or a genetic relative of the individual. And sensitive information also includes genetic information that is not health information. So, in order for genomic data to be genetic information as far as the law is concerned, it must first be personal information. So it must be about an identified or identifiable individual, and it must also fall within one of these two subcategories of sensitive information. Otherwise, it might be genomic data, but it's not genetic information for the purposes of the law. There were a couple of interesting things about this definition of genetic information within the Act that we go into in the paper, but I'll just note that it's been pointed out to us that this notion of health information as genetic information, that talks about genetic information that is or could be predictive of the health of the individual or genetic relative of the individual, might be using the term predictive genetic information in a way which is not consistent with the way in which the term predictive genetic information would be used in other contexts, in the context of health and medical research, where I understand it tends to be reserved to describe predictive genetic information, reserved to describe information in relation to an individual who's asymptomatic, whereas this definition wouldn't seem to be have any such constraints. So this is just, again, a reflection on the relationship between terms as defined within law and terms as used in other contexts in the health and medical research. So going back to when is genomic data then going to be genetic information? Well, first of all, as we say, it has to be personal information, and personal information is information about an identified or identifiable person. So when is an individual identifiable, or when is data about an identifiable person? Courts have given limited guidance on this, but we can extract some guidance from case law and also from the guidance issued by the regulator, the Office of the Australian Information Commissioner. The courts have indicated that although documents and records may not contain any obvious identifying features, they can take on the quality of identifiability in particular contexts. So it doesn't have to hold any identifiers on the face of it in order to be identifiable. You have to look at context, and that's something I'm going to keep saying. In Telstra, the court said that a determination of whether the identity can reasonably be ascertained will require an evaluative conclusion. What do they mean by that? Well, we think they mean that you have to take in a whole range of considerations. You have to evaluate the context in order to determine whether or not data is identifiable or not. It's not straightforward. It requires an evaluation of all the material circumstances. The regulator has indicated that when it comes to that contextual consideration, you have to look not only at the nature and the amount of information, but also who will hold and have access to that information, and the other information that is available, and the practicability of using that information to identify an individual. So all of these other contextual considerations are material to the evaluative conclusion, and they go beyond a simple consideration of the quality of the data itself, but extend to considering the circumstances within which the data is held. So you can't just look at the data in isolation. You have to look at the context in order to answer the question of identifiability. Within the regulatory guidance, they give an example of license plate number, and they say that a license plate number to a regular person may not actually enable an individual's identification. It will enable the police to identify an individual because they have access to the car registration database, but it may not be personal information in the hands of an individual who doesn't have access to such a database. Of course, we can also imagine other circumstances where maybe it's a company car and the company have records of who was driving what car on what day. Maybe it's, we know that it's a single, it's a family which only has one car and only one person driving it, and we see that car out on the streets. So there are different kinds of context in which we can imagine the data being interpreted and associated with a particular individual, but you have to be able to identify that context as one which is pertinent to the circumstances. The data itself, the theoretical possibility of identification is not enough. So then within the paper, we move on and we try and apply this to genomic data. And we know that within the literature, there's a lot said about volume, richness, and uniqueness of genomic data. And we go through the different types of genomic data, as we've identified at the beginning of the paper: raw data, interpreted, annotated data, and we consider the uniqueness, richness, and volumes associated with each. And our conclusion is that you can't just look at the data in isolation and determine whether or not it's genetic information. And there's some guidance which the OIRC has issued, which isn't particularly helpful. You will find within the OIRC guidance comments such as, some information is unique to a particular person and may in itself identify that person. This is taken from the OIRC. I kind of get what they mean, and we say within the paper that the more unique the data is, the more likely it is going to be able to contribute towards an individual's identification in the circumstances. And here that word may is so very important. Information that is unique to a person, like a unique tattoo, may identify a person, but it still needs to be possible to associate the data with the person in the circumstances. So even unique genomic data, even a whole genomic sequence, is not necessarily going to identify an individual if the circumstances aren't conducive to that. Significance of the features, including uniqueness, must be interpreted in context. And here we find other guidance by the OASC more helpful here, where it's technically possible to identify an individual by referencing data against other available information. Entities should also consider the likelihood that this would occur. Okay, so it's not just a scientific technical possibility, it's the likelihood that this is going to occur, which means the data environment or the data situation is going to be really important. And the data situation is going to consider all material factors, not just uniqueness, volume, or richness, but who has access to the data. Is it open access? Is it restricted access? What other information is available to those who get access? Do they only have access in a virtual lab, or can they actually take the data away with them? What would be the time, the cost, the resources involved in associating with this data with a particular individual? Here, technical, organizational, and legal methods which might constrain the possibility and the likelihood of identification all may affect the relevant and material data situation. So this evaluative process is going to be dynamic and it's going to be ongoing. This assessment of whether or not data is identifiable, unfortunately, is not a set and forget thing, particularly not as data moves through fluid and different interpretive contexts. The same information can be personal information in one context and not personal information in another. Information holdings are dynamic as the character of information changes over time, and also the ability to link that information to a person through other data changes over time. So, genomic data and genetic information, our tentative conclusion within this paper as it's being written, they're overlapping concepts, but the boundaries are not coterminous. You cannot assume that when we talk about genomic data in one context, it's going to mean genetic information as far as the law is concerned. They have different, the different concepts with different epistemic bases. Identifiability is going to depend not only upon the nature of the data, but crucially upon the context. Together, they make up the data situation, and their control over context is going to be key, and the organisation, technical, contractual and other legal methods by which that data situation is controlled. But that may be dynamic, so assessment should consider fluidity of interpretive context over time. So what? Well, this has implications for understanding what people's responsibilities are under the Privacy Act, because it goes to an understanding as to when genomic data is going to be genetic information as far as the law is concerned. And this is important only for those who have responsibilities, but also for those who have rights, the consumers that Megan was talking about earlier. And also from our perspective, it's important because it enables us to critically reflect upon those rights and responsibilities, particularly important at a time when the Privacy Act itself is under review. Okay, so that brings me to the end. Thank you for your patience. Thank you, Paula, for giving me the opportunity to present. I'm going to stop sharing now and just reiterate, this is very much a work in progress, but we hope that through this paper, we'll be able to contribute towards helping answer those questions that we've encountered in practice as questions that people are grappling with on the front line.
Thanks, Mark. That was great. And I mean, both you and Minna and Ainsley and then Megan and the team there, that you're all grappling with these questions that are, you know, are so challenging and so current at the moment. So we have a great audience with us, and I'm sure there's quite a few questions coming. So we're really happy that Minna and Ainsley can join the discussion time as well. So if you'd like to use the hand, putting up the hand function, if you can. If you can't, just maybe indicate in the chat that you have a question, and I'll come to you. So Clara, would you like to start us off? Thank you.
This is not a very well formulated question, but thank you. They were both fabulous talks, and you're both addressing such important issues that we've been struggling with for years and years and years. And your work is so helpful. And I'm trying to, in a way, reconcile the two of them. And the situation I'm thinking about is, you know, testing laboratories that are within a hospital system. So they have the genomic data stored within them within the pathology service. So it's not part of the electronic medical record, but it's still part of the hospital data systems. And how that sort of, so it's a bit different, Megan, to what you were talking about, but Mark, it probably fits within the realm of what you were talking about. Is there some intersection here where these two pieces of work come into play together? So gut reaction, as you can tell, not a well-formulated question, but just listening to those and sort of looking at the work that we're doing in data systems, in that technical area, it just seems to sit across both of those in a way.
I think that there is. I think there has to be. I think we have to understand, as Megan's work is fantastic at saying, well, this is kind of what people are expecting, what they'd like to see. Now, how well is the law currently configured to deliver that? And to what extent might systems such as My Health Record actually be better configured to meet people's wants and expectations? And to answer that question, we do have to be confident that we understand when the data within the systems is subject to the Privacy Act, when it is subject to My Health Record Act as health information as opposed to de-identified data. So we have to make sure that's clear, not only to those who are operating those systems, but to the consumers then who have expectations about how they themselves are going to be able to interact with those systems. So yes, I think you're absolutely right. And this is, I guess, the next piece of work that we might be able to do together. By together, I don't just mean Megan, Ainsley, Minna and myself, Clara.
Definitely. Thank you.
Okay, I think we had Jamie next. Thanks, Jamie.
Thank you, everybody, for the presentations. They were fascinating. My question is for Megan. One of the concerns that I've always had in this area is about the potential use of this information by insurance companies to prevent people from getting insurance or to increase premiums. And I think because of that concern, some people quite legitimately may be very wary of having, genetic testing done because they just don't want to know, because then they might be required to disclose that information, which might have personal costs to them. So I guess what I'm wondering here, at the end of your talk, you talked about push notifications, and you suggested it might be desirable for people to be able to push their information out to other people. I was wondering whether you'd also considered the kind of converse need then for people to be able to identify that they don't want to receive information because they might not want to know about a family history of some kind of illness because of the potential consequences that might have for them.
Yeah, thanks, Jamie. That's a really good point. And I hadn't kind of got as far as thinking of that, but you're absolutely right. And just as in, as it is in the way that these things currently operate, that people can say, well, no, I don't want to receive that information. That would definitely need to be part of any system-based communication tool. As far as I'm aware, I haven't really looked into it, I must say, but I would expect that one would push just an invitation to open up a document, not the document itself landing in somebody's email inbox, for instance. In terms of just the insurance issue that you raised, I didn't speak about that today. That the concerns about insurance agency access to genetic test results emerged also quite strongly in our interview data, but it is the subject of a lot of work being done by Jane Tiller, Paula Kars, and an amazing team in the HLEN project on the insurance moratorium. And so that's not an area that I feel that I need to kind of cover because it's being done so well but elsewhere. Yeah. Thanks.
Thank you.
Thanks, Megan. I think Ainsley, did you want to comment on what
Very
Megan
quick.
was saying?
Yeah, it was just a
great.
very quick finger on Jamie's comment, actually. And hi, everybody. It's the first one of these I've ever come to. Can't believe it's taken me so long. I'm now on the mailing list, so really looking forward to coming in the future. And for those who don't know me, I'm Professor of Bioethics at University of Sydney, but I have a science law background as well as bioethics. So I feel like this is a really nice group for me to hang out with. Just on Jamie's point, I think there's a really important thing about personal insurance products which are risk rated is that it's based on a contract of disclosure as well, which I'm sure you know, Jamie, but I just thought I'd make it clear that there's not necessarily pathways for insurers to go kind of independently from what the person discloses in an application. And certainly when my health record was being developed, there were questions around third-party access, including commercial entities, but it wasn't necessarily to check up on individuals. It was mainly for bigger picture kind of research and things like that. So certainly from an individual's perspective, there is this presumption of complete disclosure. When you are asked questions, you don't have to disclose beyond the questions that are asked, however. But if you give misleading or incorrect information and they can prove that, then they can invalidate your policy. So it's really just a quick point about the nature of the arrangement in place. But I think it's also a really complex area, and there's still a lot of not necessarily misunderstanding, but concern among both professionals and patients and sort of broader publics as well about what this might look like going forward. And so it is absolutely important to address them in projects like HLEN.
And if I could just tag on to the end of what Ainsley said, that just to point out that the My Health Record amending legislation also removed the possibility for insurance agencies to even request access to that information through the My Health Record system.
Thanks, Megan. Mark, did you?
That's what I was going to say. I was going
to
make mention of the prohibited purposes within the My Health Records Act.
Great, thanks. And Jeff, thank you.
Yeah, thanks for two very interesting and informative talks. I picked up on one word that Mark said because it's intrigued me and annoyed me for a while now, is what does predictive mean? I've seen it used in predictive modeling to take, data, cross-sectional data, whether a polygenic risk score predicts a particular disorder. which is purely in a modeling sense, but also about predicting, as you said, future onset disease, but also being used to talk about prediction of relapse or prediction of response to therapies. And also predictive is the actual definition, it spans being, some people might understand it as being 100% accurate, others might think it's a kind of probabilistic idea. So my question is, does the word predictive have a legal definition? How is it defined in these kind of documents, legislation?
No. I think it is a word in the statute, and so it will be subject to statutory interpretation. And statutory interpretation typically looks to understand the common or ordinary meaning of the word, and or the purpose of the legislation, try to interpret the language of the statute in order to give effect to the purpose that the law has. So the intent of those that brought the legislation into being. So there are various kind of legal rules or approaches to the interpretation of statutes which might help us understand how a court would begin to unpick this if it went to court and if it was being argued before some judges. I'm not aware of it having been argued, so I don't think we have any judicial guidance on how they would understand predictive in this context beyond the usual rules of statutory interpretation. But I do find it really interesting myself, and particularly to understand the extent to which this statutory definition might sit uncomfortably with the way in which the term is used in practice. To be honest, the extent to which it's going to matter in practice is going to be diluted by the fact that genetic information is included within the list of sensitive information twice. So it's included as a subcategory of health information, where this term predictive presumably does some work, but we're not quite sure what work it's doing. But genetic information is also included as sensitive information that's not health information. So the significance of it is going to turn on how important it is that it's categorized as health information as a subcategory of sensitive information. But it certainly won't do any work in determining whether or not it is protected information by the Privacy Act.
Thanks.
So Ainsley, thank you. Just to finish us off, thank you.
I have a question for Megan, but only if there aren't any others. I don't want to take the
I think you're right.
Okay, yeah. Megan, your talk's really great, and thank you. And I think the stuff around families, I'm not surprised that there's that divergence, because I think it is a genuine tension and genuine dilemma around both practitioners in genomics or genetics, particularly with mainstreaming from a more familial genetics environment where, it has typically been the family as the patient, to now where we're mainstreaming. And so a lot of genetic testing is starting to happen outside of that traditionally more exceptionalized environment. And so I think that's kind of maybe leading to some of this tension around the presumptions that are made around whose information is this. And this is a long-standing tension as well in both the health law and bioethics literature. But I guess what I'm wondering is, what we're also seeing with approaches like relational autonomy and sort of more feminist and care-based approaches to ethics, and just how they, are emerging more into so-called mainstream bioethics and health law work. Is genetics and genomics here actually kind of a canary in the coal mine for how we should be thinking about other forms of health data? Is this actually just an indicator that we need to be more radical with our reform of how we structure regulation of health information to maybe encourage people to have and be clear about those links? None of us is an island after all. So a slightly radical suggestion.
No, thank you, Ainsley. That's a fantastic point, and I really appreciate your making it. Thank you. And I think you're right. I mean, we're not talking here about the design of bespoke systems for genetic test results exclusively. These are medical records that will store all sorts of things. And so, yes, solving the problem or resolving the issues in relation to family versus individual rights or, matters in relation to genetic information is going to help us in a whole lot of other ways as well. Yeah, I think that's a really great point. Thank you.
Well, thank you to Megan and Mark, and also Ainsley and Minna for your contributions to the paper that Mark presented. They were fantastic papers, and we've had some really good discussion, and I hope you know, this sparks some further conversations and ideas for people. So, and thanks everyone for coming to the first HLEN seminar for the year. Our next seminar will be on Tuesday the 5th of April. So we generally try and meet on the first Tuesday of the month, unless that there's maybe a public holiday or some other reason why we can't meet. And next month we'll be looking at Mave's Law. And so Mave's Law is about the mitochondrial donation bill, which will be back before the federal parliament in late March. So this seminar, you know, will pick up where the bill is at, and it may have been passed into law by that time. So we look forward to welcoming you back for next month's seminar. So thanks again to our presenters, and all the best, everyone. Thank you.